What's up, everyone? It's Peter Tragos, the lawyer you know, and today we've gotten our answer as to whether or not Chad Daybell and Lori Vallow's case will be separated, as Chad Daybell has asked the court to do, or will the court join them together in one approximately 10-week trial. If you haven't already, take a second to subscribe to our page and like the video if you're interested in the Daybell Vallow content. So we have heard from Judge Boyce throughout this case, and it really was not surprising what his decision was, and we have some quotes that let us know how he came to the decision he came. And if you remember from our first video, breaking down the actual motion and the hearing, it was really going to come down to whether or not Judge Boyce felt like protecting Chad Daybell's constitutional right, getting this criminal defendant to trial, not having his justice delayed, because we always forget, but right now he's presumed innocent. He has not been convicted. He is not a convicted murderer. He is not sitting in prison. He has the benefit of the doubt and the presumption of innocence on his side. So do we want to get him to trial and get him his day in court? You're weighing that and his rights as a citizen versus judicial economy and the money and time it's going to spend to try this case that seems very similar twice. And we talked about all the other issues and whether or not there was enough evidence that was going to be different, whether or not it was going to be very prejudicial for one client or the other to charge them and try them together. We talked through how there really wasn't a lot there. It really came down to those two factors. And interestingly enough, the judge did not even seem to mention one of the two factors we discussed when he came down with his answer not to sever these trials. These cases and these defendants, Lori Vallow and Chad Daybell, will be tried together when they're facing the death penalty on multiple murder charges. Let's hear why the judge came to this conclusion. Having determined that the defense has not met its burden to persuade the court that a jury is likely to confuse evidence in this case, that the defense will be unable to meaningfully present a defense, or that a jury is likely to base a guilt determination, in this case due to evidence of criminal disposition, the court must conclude that the case will not be severed. So the judge is saying, technically you've not met your burden. In order to get a case severed, you have to show that you're not going to be able to present your defenses. It's going to confuse the jury. There's so much different evidence that does not apply to your case, and we don't have that here. And the judge is absolutely correct by the letter of the law. But then later, the court also said that the court concludes that a joint trial in this case will serve the interests of justice by providing for judicial economy and efficiency and avoiding possible inconsistent verdicts. Therefore, the motion for severance on this basis is denied. And again, we agree there's not a big confusion or factual difference. These trials are likely to be very similar. But the way we look at it, because we represent people, either plaintiffs in personal injury cases or criminal defendants, we see how this affects a person, a citizen of the United States. And sometimes judges totally miss this fact and disregard the rights and the wants and what's fair for the person involved, and they look at the bigger picture. And a lot of times judges become judges without ever having clients. They just go from being state attorneys to judges. They go from judicial clerkships to, some firm that is in-house counsel and they don't actually represent people, to becoming judges. And they take tracks that don't allow them to actually deal with a client day in and day out. On a separate note, that's something that is so great about the newest Supreme Court Justice nominee, that she was a defense attorney and she represented people and she was the judge over people before getting up to the Supreme Court. Now, whatever you feel about her politics, whether you agree with them or disagree, and there's no judge I agree with across the board, I'll just tell you. But when we look at qualifications for judges, every lawyer will agree. Every lawyer that practices in front of judges will agree that a judge that has had clients, that has been in the trenches, that knows what it's like to answer to a client, to explain to a client why there's another delay, why this is taking so long, why this is so expensive, why we have to keep having these hearings, why this case keeps getting continued. We need judges like that making these decisions, because in everything that I've seen, the judge did not even mention the fact that this is going to cause huge delays for Chad Daybell. He just has to sit here and wait now until Lori Vallow is competent. And even when she is competent, Lori Vallow has the right to adequately prepare a defense for her case. So we can't rush Lori Vallow. Therefore, we're going to have to slow down Chad Daybell and just make him sit and wait. And whatever you think about him, however despicable you may think he is, he's a person, he's a citizen at this point in our country who's presumed innocent. He has not been convicted yet, and that's important. Because this is hanging over his head. He obviously, let's assume in a hypothetical situation, he's found not guilty at trial. This man right now, he can't find a job. He can't talk to any family members that may want to talk to him. He can't live a normal life at all with this hanging over his head. But if he's not guilty, at least he can start to try to rebuild his life. Now, if he's guilty, sure. We delayed the inevitable. He's going to be in prison for the rest of his life. We get it. He's even facing the death penalty potentially. So we get it. If he's guilty, it doesn't make a difference. But we can't presume him guilty, especially as a judge in our legal system. And to me, this order almost presumes him guilty. I'm not saying the judge doing that. The judge would never presume him guilty. I think the judge is just thinking about it differently than I would as a practicing lawyer. And he's the judge. It's his call. It could be appealed, but it's his call at this point. And he's saying, for judicial economy reasons, and fairly, and this is an argument I'm sure the judge would make, that by joining these trials together, he's actually providing fairness and constitutional protections to other criminal defendants who will have their cases tried in that 10-week period that they would have had to try this case twice. Instead of 10 weeks, it would be 20 weeks. So he could come back at me and say, you know what, Peter, Mr. Know-it-all, lawyer you know, I'm actually providing judicial economy for tons of clients, even if I am denying Chad Daybell a sooner trial than what he will likely get when I join these together. And those are all factors he had to weigh. Okay, and he would be right in arguing that. But I'm just looking at the case in front of us and the motion in front of us as Chad Daybell. And there are a million reasons cases get continued and delayed. So I find it very unlikely that this one trial is going to really screw up everything. But I've also heard numbers thrown out that it would cost approximately $400,000 extra from the state to try this case twice. And well, that's a big number and we don't want to waste that. Imagine you're Chad Daybell, or imagine this happens to you. All of the tax dollars you've been paying over your lifetime that go to this process, the state attorneys, the judges, the bailiffs, everybody that gets paid by the government in cases like this, you would want your case to get to trial. You would want fairness. You would want justice, especially if you were pleading not guilty and saying you didn't do what you're charged with. And Chad Daybell is being denied that right, in my opinion. But one thing the judge would be able to throw in my face is Chad Daybell has waived his speedy trial. And once you waive your speedy trial, you lose the right to say, I want my case tried now. My constitutional rights protect me against this unruly delay that's occurring to me in my case. And he very likely did waive speedy trial. I don't know that to be a fact. I didn't check the whole docket. But just about every criminal defendant waives speedy trial because you can't ask for any delays. You can't get anything from the state sometimes. So you have to agree to waive speedy trial in order to get a continuance, to not push yourself to trial right away. Because the state holds all the cards in the beginning of the case. They've done this huge investigation before they charge you with a crime. And your criminal defense attorney is playing catch up. So for the most part, speedy trial in the way that it's written and used right now in our court system is not a major benefit for criminal defendants. So therefore, by waiving speedy trial, technically, maybe Chad Daybell has lost his ability to make this argument. Maybe that's where the judge stands. I don't feel that's fair, in my opinion. I think when we have a situation like this, let's let the criminal defendant put this behind him and get this case tried. But as always, what I want to know is what you all think, the potential jurors and the citizens that could one day find themselves in a situation, maybe not to the level Chad Daybell is, but to the level you're going against the government and government dollars that you've contributed to, and now they don't want to waste giving you what is your right, and that is a speedy trial, or a trial that is not unduly delayed by things that are out of your control. So let me know in the comments if you think this was fair or unfair and what you think should happen in this case. And as always, let me know the questions that you have. But for now, that's all we've got. And make sure you like the video on the way out. Thanks for watching this episode of The Lawyer You Know. If you like this content, please share it with your friends. Make sure you subscribe to our page and like our videos. If you want some interaction, get in the comments and we'll be sure to get back to you. If you want to know any more information about our firm or this page, you can find out in the description or visit tragoslaw.com. We post multiple times throughout the week, so make sure you hit that bell so you can get the notification and not miss out on the next episode.